I want to take you guys back to the year of 2006. There were many trials and tribulations that went on throughout that year. I'm sure a lot of us as students went through a lot whenever we were of that young age, not even double digits yet, wondering which game we were going to play on our Wii or Nintendo or whichever console you preferred. At the end of the day, everyone's problems are subjective. You know, everybody has their own stuff that they deal with. Dr. Knight, I'm sure you had many problems that you were going through in 2006. But now I want you to imagine that your name is now Joshua Cross, and you are being tried on felony charges for domestic violent crimes. And not only are you being charged for these domestic violent crimes, no. These aren't even your first domestic violent crimes. Within this trial emerges the question of intent and differentiating literal versus subjective viewpoints. So what I mean by that is talking about what exactly counts as threatening messages or threatening somebody on social media platforms. Is it something that is very straight cut, to the point, literal, no room for discussion about it, or is it more of a subjective view? And I think that the Supreme Court and the cases that we're going to talk about today, such as Joshua Cross, which actually is the president, isn't even the main case. But I think that they would argue that it is subjective, but it is also very easy to cross that line. So back to the case, Cross had multiple charges for domestic abuse, like I stated before. This isn't even the first of his charges that he has ever had. He created multiple Facebook accounts and was just constantly harassing this victim. She would block him, didn't matter, he would make a new account. She would try to delete him or try to give him his way, didn't matter. He would not stop. And so she ended up having to get the court involved. Little do you know, as Joshua Cross, or little does he know, this would impact the way that courts look at the true threat issue for years to come. And everything comes full circle when in 2023, the same sentiment comes up in a similar case. So this is going to be the main case that we're discussing today, the main court case. Now, instead of being in Joshua Cross's shoes, you are now in the position of Billy Raymond Counterman. And these two cases have a lot more similarities than just what the precedent has been set on. So I want to explain the case a little bit by first reading the introductory paragraph from the Supreme Court document. The case was very interesting. The document specifically went into a lot of details, went to a lot of specifics, and all of this is really just to set the standard for what we're looking for, because we're going to be formulating arguments based on communication law, based on the literal versus subjective terming and processes whenever it comes to charging someone of harassment online. So Justice Kagan delivered the following opinion, and this was to start off the crux of the case in the document. Quote, "True threats of violence are outside the bounds of First Amendment protection and punishable as crimes. Today, we consider a criminal conviction for communications failing within the historically unprecedented category." And I do want to take a moment to highlight the unprecedented category part. Yes, there was already a case with Joshua Cross. It was People v. Cross. But this is still generally considered an unprecedented category, which speaks volumes to the ramifications at the end that we'll get to. Continuing. The question presented in whether the First Amendment still requires proof that the defendant had some subjective understanding of the threatening nature of his statements, which is really important. It's basically the crux of how they find him guilty. Spoiler alert, they do find him guilty. We hold that it does, but that a mental state of recklessness is sufficient. The state must show that the defendant consciously disregarded a substantial risk that his communications would be viewed as threatening violence. The state need not prove any more demanding from the subjective intent to threaten another. This is a very strong opinion piece. This is something that is very cut and dry. This isn't something that really has a lot of room for dilly-dallying. It's just straight to the point. So just to get into the main case with Counterman, from 2014 to 2016, Counterman sent hundreds hundreds of messages to who the documents call CW. CW is going to be the victim. In this case, she is the person who was being harassed. They were strangers. They did not know each other. In fact, CW was a singer and musician, did not know Counterman in any regard. And I think it's very interesting that Facebook is the common theme here with harassing people online. But anyways, besides the point, Counterman didn't always act like they were strangers. In fact, sometimes Counterman actually acted like they had known each other for years. One of the texts that he would send her, and there would be similar texts. "Good morning, sweetheart. I'm going to the store. Would you like anything?" That's not even necessarily threatening, but just really off-putting to hear from a stranger. Other messages might include that were, a little bit more creepy, a little bit more disturbing, something that doesn't really make you feel as safe. "Was that you in the white Jeep? A fine display with your partner. F off permanently. You're not being good for human relations. Die." These are just a few messages that, when I first read them, sent chills down my spine. This caused CW, obviously, to have huge emotional distress. This was later proven in the case, and it actually ended up helping with the guilty verdict that CW indeed did have emotional distress because of these messages. They had massive anxiety and paranoia. I mean, could you imagine? It's not even just somebody knowing that you drive a white Jeep, but it's saying, "Was that you in the white Jeep?" Meaning that they were watching them while they were in the white Jeep, telling them to F off permanently, aka die, or telling them straight up to die. These are more of the threatening messages that the case really highlights on. The court looked at these, and you can just very clearly tell that these are threatening messages. But you do have to go through the process. Colorado charged Counterman under a statute making it unlawful to, quote, "repeatedly make any form of communication with another person in a manner that would cause a reasonable person to suffer serious emotional distress," and does cause that person to suffer serious emotional distress. So this was a quote for what they charged him on and how they charged him. So it's very important the effects that CW had off of these messages. As far as the precedent goes, he argued against this, pretty much all of these claims, except for the things that were pretty undeniable, like the text messages. He argued against this quote that I stated by claiming that his statements were not true threats. He didn't mean them as threatening. He was just talking, and they were empty. He wasn't planning on doing anything, actually. And this prompted the courts swiftly to assess the true threat issue using the objective reasonable person standard, which was used in People v. Cross. Yes, Joshua Cross. So we come full circle now with Facebook, with harassment, with the same defense even. Cross argued the same thing, that these weren't true threats, and he didn't mean them in a truthful, threatening way, when it's literally telling them to die, and it's literally saying, "Oh, that's a fine display with your partner. Oh, is that you in the white Jeep?" I mean, you're like hiding behind a bush or something, just watching. It's pretty distraught. It is interesting to get inside the minds of these people who are doing these things to not even just women, but just other people in general. It is insane. And the fact that they're really, it's like I said in the quote, this is a, generally unprecedented area. It's very fascinating. But to continue, the court had to show that a reasonable person would have viewed the Facebook messages as threatening. So this isn't even the person who is being personally messaged. Just in general, would a person find these messages threatening? If someone texted you to F off permanently, or that you had a fine display with your partner, it would be like your wife or your husband or your partner. Would you consider these types of messages threatening? Even, I think, personally, I would even consider the "good morning, sweetheart, I'm going to the store, would you like anything?" I would be like, what do you mean? I would consider that a little bit threatening too, honestly, coming from a total stranger who would send these messages constantly and wouldn't stop. It was the same thing with Cross, even in terms of, like, she would block him, and then he would just make a new account and keep messaging her, and would not leave them alone at all. But Anyway, the case went a similar way that People v. Cross went. I think People v. Cross, if I'm not mistaken, I think it was and ended up being a unanimous vote, but at first it was 8-1. But Counterman was found guilty on a 7-2 decision, which I think is quite interesting. I think that the counter arguments weren't super well articulated in the case, but a 7-2 decision is still pretty close to unanimous. As far as the big arguments in the case, we're talking about the overall argumentation that went on. Really, the only fence that he had was these weren't true threats. I was just kidding, just trying to have fun. But it's really hard to prove that whenever there are literally hundreds of these messages. You can delete your account, you can block people all day long, but the messages are still there. Your social media footprint is still going to be there. And I think a lot of people, even in the modern era, just don't realize that that's going to happen. That, you know, things like Snapchat capturing pictures that you might take on there. It is very scary, but it's also very useful whenever talking about cases like this and helping the victims find closure. Counterman was aware of the threatening aspects of his messages. The Supreme Court ended up deciding that he was aware. Which constitutes the guilty verdict, honestly. But that was one of the big arguments, is that he was aware. And a lot of the counter arguments could be mental health and how you are mentally unwell enough to do these types of things to people and not completely understand the ramifications of said messages. But they found Counterman completely aware. He knew what he was doing. He did it with the intent of harming her or harming them. Speech is constitutionally protected, and I say harming them because this happened multiple times, not even with Cross, but I think with Counterman as well. I think they had more than one, but speech is constitutionally protected. This was an argument that the Supreme Court harped on as well, but speech that is a true threat is not protected. Just like you can threaten someone physically in person, you can threaten someone online and it be considered a true threat. And a lot of the ramifications of the verdict specifically for Cross, Cross indirectly, this court case, People v. Cross, indirectly affected Counterman's. It's almost uncanny how much they had in common. The ruling set the standard for online protection on social media through communication law. And so, just some thoughts. I think that having two court cases go over basically the same issue and them kind of bouncing off each other in terms of the verdicts and the, you know, just overall ramifications for how the victims were affected, how people are going to now look at social media and understand that you can't just say anything, and that if you're going to harass someone, you can be held liable. But what are your thoughts? What do you think? I think that the victims were definitely served justice. I think this was a very interesting case, or two cases to look at, and I think they balanced out each other very well in terms of deciding the verdict and keeping the continuity between Cross and Counterman. So yeah, that's everything. Let me know your thoughts. Let me know what you think. Let me know if you disagree. Let me know if you find more information. And if anything was misconstrued or if I left any important details out that you somehow or somewhat know, please make sure to leave them. Yeah, thank you.